On what? Tuesday.
ଆଉ 15 ଦିନ ଆଉ ରହୁ କିଛି ନାହିଁ ମୁଁ ମନେ କରୁନି କିନ୍ତୁ देखिए
Item 17. Item 17. 15 note of commission bank.
Item 28 came last week, the execution matter. The Lordship ordered that the review has to be had. There is a review in this matter. The appeal council told review it has to come on Friday. It did not come on Friday. So again, if it reaches, again the same question will come. The review is pending, so that has to be listed on Friday. The review has to be heard before execution. 119. Review number 119 of 2023. Arising out of CD 126 of 2023. हाँ दो 15th September 2023 थिला ऑर्डर ହେଇଥିଲା 22nd September 2023 को लिस्ट हवा को तापर लिस्ट है नहीं I am giving a memo. Sir, matter may not be this. Can we adjourn to some other day here? It will come along with that. No, let it come after vacation so that they serve the file and the matter get cooled and then they again. मैं vacation रहूँगी तो आशुता रही Friday. हाँ, I am giving the memo. I am giving comprehension. Yes, yes.
Item 38. Item 38 Honorable Mr. Mahanti, 15 days time already return of submission filed by the appellant.
Sir, item 3. Item 3. Again. Sir, certified commission.
एकदम धक्का वस्तु से वन को सीधे
Again. On behalf of Mr. Ponda. Again.
I am for the statutory reporting, welfare data, reports of the I think they report. That of order to 8 days delay, filing the copy. Office.
Item 2. Item number 2.
Again. Petition.
My export is submissions. सर एटा जो रिविजन गोटे फाइल होइथिला suppressing all the facts I have already appeared सर सर टिके 12-10 ऑर्डर ता देखा जाओ 12-10-23 मो रिविजन तळ कोर्ट रे कंप्लेनेंट है एठी मु रेस्पोंडेंट एथे कोन सर 12-10-23 रे सर ऑर्डर हेतिला Mr. B.N. Panda appeared for the OP and submitted that his name has not been reflected in the cause list. DFR not issue reminder concerned district commission DFR forthwith list this matter 20/11/2023 awaiting the DFR. Thereafter, my learned brother filed a memo without my signature, without serving me copy. Memo has been filed on
31/10/2023 এবং সেঠিরে সেই মেমোটা যে দেলে 25 योर ऑनर 25/10/23 रे से गोटे मेमो फाइल कले से मत कॉपी सर्विस हेलानी से मैटरटा आसीगला 31/10 रे 31/10 रे ऑर्डर कौन है वी हैव ऑलरेडी द एप्लिकेशन हैज बीन फाइल्ड बाय द लॉर्ड काउंसिल द रिविजन पिटिशन रिकॉल द वारंट ऑफ अरेस्ट issued against the branch manager Andhra Bank Jaspur Road branch by the Lorraine District Commission Jaspur. This Lorraine District Commission Jaspur issue warrant arrest against DFR Jaspur IIC PS2 arrest the branch manager. We have already admitted the revision had the Lorraine Council for the revision period peruse the document filed before us as an intermediate we direct that shall be stay up of further proceeding EA pending before the Lorraine Commissioner. এই যে অর্ডারটা স্যার হেলা বিহাইন্ড মাই ব্যাক से मत कॉपी सर्विस कले 20/11 को लिस्टिंग पाई ऑर्डर हैला किंतु 31/10 रे लिस्ट हे गला एटा को मु चैलेंज कली हाई कोर्ट रे हाई कोर्ट चैलेंज कला पर हाई कोर्ट कहिले रिवीजन रे विभिन्न देखाला होय रिवीजन इज मेंटेनेबल और नॉट तापर नोटिस हैला नोटिस रा अपियर कला पर कोर्ट कले इमीडिएटली एक्सपेडिशियसली एटा को डिसाइड करिया पे डायरेक्शन हैला जोटा सर्टिफाइड कॉपी माजी सबमिट कली नाउ क्वेश्चन इज ही हैज फाइल ए रिवीजन पिटिशन अंडर सेक्शन
या आपन लास्ट से
की सर आगे कैसे जाने नहीं नुआ छरा एथिरे सर सी गोटे पिटिशन फाइल कले अंडर सेक्शन 47 थर्ड बी ऑफ द कंज्यूमर प्रोटेक्शन एक्ट 47 थर्ड बी टा एल्यूडेड टू recall of the orders and pass appropriate orders in any consumer dispute which is pending before or has been decided by the district commission within the state, where it appears that the state commission and such a district commission has exercised a jurisdiction not vested in its bylaw, or has failed to exercise a jurisdiction so vested, or has acted in exercise of jurisdiction illegally or with material irregularity. এই সেকশন উপরে এটা স্যার কিছু আসুনি মেরিট রে কেস ডিসাইড হেলা मेरिट रे केस सारे डिसाइड होला परे वारंट इश्यू होला जेतडो से माने कंप्लाई करलेन सर कोन पई हमें वारंट इश्यू कलु 2015 रो हमर गोटे फिक्स डिपॉजिट से ए केस से तो किछि कनेक्टेड नाही से पैसाटा को भी से बंद कर दउतै हमको दउ नाहाती कोड आपण कमिशन कैटेगोरिकली कहले जे एई केस छोड़ा अन्य केस रे कोनोस जगह बैंक इंटरफेयर करि परिबो नाही इज बैड इन लॉ कोर्ट ऑर्डर इन स्पाइट ऑफ दैट से पर्यंत हमर फिक्स डिपॉजिट रिलीज करना कि बेड रे हॉस्पिटलाइज ता स्त्री मरिबो कि मोहन कते बेले कोन होबो कहि हो ना नो अपील हैज बीन फाइल नथिंग एल्स जाई कमिशन सर नेशनल कमिशन काई अछि ऑर्डर इन्वेस्टर कमिशन को जा अपील ले हेटी गले डिपॉजिट करिया को पड़िबो न करि कि एठी गोटे रिवीजन रे आसी कि बंद करिया को चाहि এবং স্যার মেমো আলাউ হচ্ছে মোর উইদাউট নলেজ রে কোর্ট রে অর্ডর হচ্ছে মোর নলেজ নাই মু আপিয়র করি সারিছি স্যার जो दिन অর্ডরটা হলা সেদিন মো যা নাই না লিস্ট भी না ভালনি লিস্ট भी মো না ভালনি তার 2 মাস আগে মু আপিয়র করছি অর্ডরটা হলা जो স্টে অর্ডরটা হলা স্যার কপি দেবে না मुझे एकाथरे रिवीजन हियरिंग कर देली रिवीजन नॉट मेंटेनेबल ए जो सेक्शन 47 सबसेक्शन 3 रेसिडेंट सर आज पर ना मो हियरिंग ता मो करिबिन सर आर्गुमेंट यस सर माय सबमिशन इज सर 47(3) इज नॉट मेंटेनेबल यस What is it? ऑलरेडी गलानी 2018 तापरे कमिशन कर अपील रे हला 365 अपील वारंट यस सर यस सर से मत कॉपी दे ना ना सर मु हाईकोर्ट को पड़े मुझे जो ऑर्डरटा सर है ना ना सर ऑलरेडी मु अपियर करी ए केस रे कॉपी आपण ऑर्डर करथिले दबा पई देई नाहंती एवं तापर सर 2011 को ऑर्डर पई रहिला से ता पूर्व मेमो फाइल कर दे कि लिस्टिंग करी कि मो ना नहीं ऑर्डर नहीं गले सेटा कहय चाहू ता पूर्व मो ना अछि माने ऑर्डर माने हियरिंग कला मो विदाउट माय एब्सेंट सर मु कि मो ना आसिलानी मोर कॉपी नहीं मु जानि छी 2011 को लिस्टिंग अछि मते कॉपी सर्विस करिवे ता पूर्व सर 31/10 रे ऑर्डर होछि हाईकोर्ट को जाइथिलु मु जाइथिलु हाँ अच्छी सर एथि सर जो ऑर्डर है अपील रे आदि डेट थिला रिविजन सर हे परियो नल अपील एलसीआर ता कॉल करी मैंडेटरी इट इज ए रिविजन पिटिशन सर डीएफआर ता सेथरे हमर किछ कहै नै डीएफआर ता कोर्ट मगै छै कोर्ट रो आसीबो डीएफआर सर मैंडेटरी हला जदी अपील फाइल हला सेथरे एलसीआर ता आसीबा इज मैंडेटरी और कंपल्सरी एटा हला सर रिविजन whether revision is maintainable under or not under section 47 subsection 3 of the act मो कहया कथा 47 एक्ट एभलिया नाही किछि रिविजन इज मेंटेनेबल मु सेटा चैलेंज करछि आ सर डीएफआर आसीले मोर किछि नाही जे आसीबो आसीबो न आसीबो मोर पिटिशनर गोलक बिहारी स्वाई आई एम अपियरिंग पिटिशनर पाई तीनटा सर एठी बैंक मैनेजर यस हाँ यस ना 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 सर ना सर डीएफआर टा आसीबा आपण मते क्वेश्चन कले डीएफआर टा आसीबो न आसीबो मु सेटा जान नै डीएफआर कले कोटा हाँ 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 अच्छी मो पाखे सर्टिफिकेट कॉपी रो मु ऑलरेडी हाई कोर्ट सब फाइल करथिली तार कॉपी मो पाखे अछि सब जान सब हाईकोर्ट रे सर्टिफाइड कर फाइल करथिलु आगे मोर टिके हाईकोर्ट रे केस अछि सर से तो ये पानी ग्रे को कोर्ट रे सर केतर पडियो कहियो सेठू मु दौडी की आसी छी एकदम आपण रखंतु जदि से आसीबे जाय हियरिंग करिवे माने ऑर्डर पे रखिवे जा करिवे आपण सर आ गुटे डेट कर दियंतु हां अब डेट कर दियंतु जदि न से दिन हियरिंग कर सर 18 मो पाखे सर एबे अच्छी मु सब दे देबी सबमिट कर देबी ना ऑर्डर कोठी सर चैलेंज हेनी हाँ स्टेट डिवीजन आमर जो सीसी केस है 2018 रे डिस्पोज ऑफ है सेटा से चैलेंज कले एठी अपील ले 365 सेठिरे कोर्ट ऑर्डर कले जे तुमे ता टका को मो पाखे अछि जदि कहि पढिबी सेठिरे इंटरफेयर करि परिबनी व्हिच इज बैड इन लॉ माने तार 2015 जो फिक्स डिपॉजिट अछि ता दर तुमे हाथ मारि परिबनी क्लियर कट कइले ता परे सर ए ऑर्डर होबार एग्जीक्यूशन फाइल कली इन टाइम सेठी जासपुर जते बेला अपील पीरियड ओवर हे गला ए 23 रे 21 रे सतरे कोरोना पई हो नथला दीटा तीनटा केस ना ना फाइल भी हमें करिथिलु सेटा फेर विथड्रॉ करके फ्रेश एडजुडिकेशन पई करेलु ट्वेंटी वन नहीं आमे हरी नुहे सर because my lord my legitimate fixed deposit has been deposited and it has no way connected with this case final order it is a final order जो appeal सी एग्जीक्यूशन टाको चैलेंज करते सर एग्जीक्यूशन टाको डिस्पोज ऑफ डायरेक्शन कर दोना हमें फ्रेश एग्जीक्यूशन पूरी फाइल कर एग्जीक्यूशन इज देयर इन नो बार एग्जीक्यूशन फाइल ही परियो काना जेहेतु अपील हैज नॉट बीन पेंडिंग हां ओके सर हां इट हां सर ना आ गोटे सर 500 हम वो डेट कर कोर्ट जो खोली को गोटे कर 20 21 से दिन सर मु सब सप्लाई कर देबी सीसी केस केबे अपील केते उनी 20 21 की रख दंतो जून 21 हां जून 21 हाँ सर सर हाँ 18-19 जो हाँ
Item 4.
Tomorrow we will call for.
হাইটটা এই বছর কষ্ট আসছে কষ্ট
अपील मेमोटा देना है
ଅଛି କୋର୍ଟ କପି ଅଛି
जैसे का आप आपके यहाँ पे हो रहा है वी आर नॉट राइटिंग
It's complicated.
Seven. Despite service of notice, effectively nobody is appearing for the respondent. Though Mr. Sinha was appearing in the court below. You are omnipresent.
ପଠେଇଛି କାଳେ ମୁଁ ପଠେଇ ଦେଇଛି ଆଉ ଯଦି ଯାହା ଭିତରେ ଯାଇ ପହଞ୍ଚିଗଲି ମୁଁ ଦେଇଦେବି ସାଙ୍ଗେ ସାଙ୍ଗେ ପଠେଇଛି ଆସିଲା
ବାସୁଦେବ ପାଣିଗ୍ରାହୀ ଛୁଟି ପଡ଼ିଲା hello delay
ପାଞ୍ଚ ଦିନ ଭିତରେ
नहीं छुट्टी ରହିବି ଛୁଟି ପଡ଼ିବ we are also on talk for a compromise ଛୁଟି ପଡ଼ିବ
କହୁଛନ୍ତି
117 ଦିନ ଦିନ ଛୁଟି ପଡ଼ୁ ରହୁ we may
ଫାଷ୍ଟ
20 ପରେ ରହିବୁ खूब फर्स्ट जून फर्स्ट वीक देखो जो 20 तारीख खोलियो देखिए आगे 20 रे हम कॉम्प्रोमाइज करे कोन मालर फुटुल टू जून पड़ी पड़ी
item 8
You ma'am appearing the amicus curiae in the matter.
I am the opposite party.
I received only yesterday evening.
pre-seizure, post-seizure notice, including notice demanding the complainant borrower to deposit the outstanding dues. That I will verify from our records.
That was regarding whether pre-seizure notice, whether the even if the agreement does not provide for the same, whether it is compulsory or not on part of the financier. In this particular case, I went through the reply filed by the financier. They have admitted that they have sent pre-seizure as well as post-seizure and pre-sale notice, but they have not attached any document to their petition to establish the same. If the financier has made it clear through its conduct that it has to send a pre-season notice, which in this case it has, because in its petition they have said that they have sent. Therefore, it is incumbent on them to show that the notice was duly sufficient. It reached the petitioner in the present case, and she was properly intimated. It should have. They have to show that it was duly served on the. It was. I think paragraph 89. I will go through the same. I only received it yesterday. That the complainant has taken only a stand saying that she was only served with a notice that was pre-sale notice 7 days before the sale. Pre-seizure notice, she has not taken any stand whether she has received or not. She has made it clear that she has received only one notice, that is the pre-sale notice for 7 days. And thereafter, the petitioner went before the Honorable High Court, and Honorable High Court directed them to pay 4 lakh rupees. They made that payment through they provided the DD of the same to the company through speed post. And by the time the company received, the company had already disposed of that particular asset. Her claim is that even though that asset was sold, was auctioned, she was neither given pre-sale notice, pre-auction notice. She was not intimated after the auction at what amount that particular year was sold off, and whether after satisfying the rest of the amount that was due, how much amount was left, whether she will be returned, she was informed nothing. So in this petition, she has filed for that amount. Whether whatever the balance amount after the auction and adjustment of the loan amount, whatever the rest amount is left, she has filed.
Primary the basic document of pre-season notice, not completely served.
Sir.
They have taken the stand that has been duly sent or so sent is not served.
No.
So in such a situation, they have to plead and prove.
They have to plead and prove.
What is the name of it?
The burden lies on the financial company.
That has been duly pleaded and
They have pleaded this.
evidence on record.
They have not attached any evidence. The financier has attached no evidence to their their objection. It is a.
In the objection, it has.
Part of the pleading that it has been duly served.
No, we have stated in our objection that pre and post seizure intimation, so also before sale, letter was issued to the borrower.
So far the third aspect is concerned regarding pre-sale notice.
Sir.
That has been admitted by the other side. That's what they say. But so far the pre-season notice is concerned. Although you pleaded and proof, but the proof you are giving that duly served.
I will obtain those proofs. I will obtain with affidavit.
The base is not there.
Sir.
All superstructure is followed.
Aye.
This is fundamental. Because the reverse of the private testing effect is made out by the complainant. The ownership is
Yes.
it is reverse. I think that state that result that how much is their responsibility so far as reverse ownership is concerned. Right? So that has to be duly treated by them and proved by them.
Yes.
And once they fail in doing that, then naturally I want to needs to be further.
Sir, 2 weeks only time. Yes. हाँ सर आगे आगे yes
Will let us move to that basic.
sir pre and post season intimation सौर proper सौर भेजिल नहीं से evidence टा मारी बोलूँ with affidavit complainant with no sir सी complainant का भाई
Yeah.
on the last occasion she was there. His associate Miss Sudha Mahanti was there, but today he is absent and Mr. Acharya has been engaged as advocate. Yes.
Your Honor, if I may, in this petition, one of the major stress of the petitioner is on the question of the validity of the auction, whether the auction was duly conducted, what amount it was sold. And to that effect, no averment has been taken by the financier in the objection. If instruction regarding that also may be
That
obtained
order was passed.
at the
I am
same.
to
But there are two only questions: when the auction was conducted, whether that was before or after the Honorable High Court's order, and the second thing is that what amount that year was auctioned off, because that will determine the claim of the petitioner, because the petitioner is claiming the balance amount. So that has also not been clarified. If these two details could also be obtained, at what amount?
Dependent on the fairness of the auction process. Depends on the fairness of the auction. If it has been done bona fide and fair, as a prudent man is supposed to do, then naturally the complainant would be liable to pay the balance. But so that fairness has to be proved by them.
Regarding that only, I was, if they could be asked to.
All are done as auction, but most of them are done by negotiation. That is a basic difference between negotiation and auction.
auction. Yes.
Auction always presupposes public auction. That means you advertise, people get a chance to participate. Then the maximum bid is made so that the original borrower gets the maximum value out of that.
Yes.
That means you are a trustee for that particular period. You don't like authorized official in Service Act.
Sir.
Same thing.
Same.
Same thing, your job is that. If you fail in that, then naturally you may be liable. Vicariously liable, that particular financer. You must have seen this recent judgment of the Honorable Supreme Court. The staff of the bank, suppose does something wrong, and the bank is vicariously liable.
For act of his own employee, liability comes to bank.
You kindly give your mobile number. Mobile number
Data केवल करूँ.
Immediate after vacation.
छब्बीस 26
Item 9.
आज सर कौन डॉक्यूमेंट गोटे फाइल कराला टेक्निकल रिपोर्ट एफिडेविट बाय वे ऑफ एफिडेविट मैं एफिडेविट कर देछि कॉपी तुम दे कॉपी एक्सपर्ट स्टाटस सहित हम दे दी
Copy to copy नहीं
तो एमाने ये सेट एक्सपर्ट है
की सेट एक्सपर्ट है हमें लास्ट
देखो
टाइम
सर
एविडेंस
सर से
देछु
रिटन वर्जन दे ना दी
रिटन वर्जन दिया है
ना
आज्ञा।
देखो हजर रिकॉर्ड अछि
हां हजर में ऑर्डर के देखु अपन सिंग संयोजन कर देना हो ये सिंग ताका पर
मेसिन अछि इटी सर ये रे हमर डेप्यूटी डायरेक्टर एग्रीकल्चर करे से आम सरकार से आम कहली सब्सिडी आम नहीं लोन तेणु आम देदेलु फटो जार दिया कैन आई शो यू फटो मो प्रेयर हूँ मोर जो मत मेसीन गोटे फ्रेश नुआ मेसीन दिया जाए कहीं रिपोर्ट अनुसार से कहते हैं चलनी मेसीन टेक्नीशियन आसी कहते मो मेसीन आम सरेंडर करदेलु ये जोटा एग्रीकल्चर ऑफिस को देदेलु आज्ञा कौन कहले सोलह नहीं सुन सर नहीं सर शुणु सी आमर यहाँ गवर्नमेंट सब्सिडी एग्रीकल्चर लोन टे नहीं बैंक लोन ना ये सब्सिडी पाइला केटा पाइल मैंने ये चलला चलला न चलिया द्वारा आम कहलु आपको कहलु कई शुणिले तेणु बाध्य जेहतु आम एग्रीकल्चर गवर्नमेंट नहीं सब्सिडी नहीं करते आम गवर्नमेंट को नहीं सरेंडर कर सर ये बहुत आम कष्ट पाइल से लोकटा सुइसाइड कर दूसरा गला देह खराब भी हस्पिटालाइज आज्ञा ये जो बैंक आम बैंक तो लोन नहीं 9,50,000 तेणु से आम एपटे केस फाइल आम तो स्टेप कर तेणु से प्रेसर कले सर्विस एक्ट नोटिस देते सब कले लास्ट
सेटा आमर एक्चुअली मॉर्गेज नो मॉर्गेज प्रॉपर्टी न नहीं कि अन्य गोटे प्रॉपर्टी आमर थला जो सेल होम स्टेट प्रॉपर्टी ताको सेल सेल कर दे और ये सेल प्रोसीजर एडजस्ट कर दे आगे हैं? नहीं नहीं प्रॉपर्टी मॉर्गेज प्रॉपर्टी आज भी शोर प्रॉपर्टी आज्ञा ମୁଁ ସାର୍ ଦେଇଛି ଆପଣଙ୍କୁ ରିପୋର୍ଟ ଟେକ୍ନିସିଆନ୍ ରିପୋର୍ଟ ଦେଇଛି ସେଟା ମୁଁ କହୁ ସବମିଟ୍ କରୁଛି ଯେ ସେଟା ଅଛି ବର୍ତ୍ତମାନ ଅଫିସରେ ଏଗ୍ରିକଲଚର ଅଫିସରେ ଅଛି ସିଏ ସାର୍ କମ୍ପ୍ଲେନ୍ ଶୁଣନ୍ତୁ subsidy is 25%. 6 lakhs they are given subsidy. Yes.
So in such a situation, in what capacity they have received it from you?
They have received they have given letter, you can see. It's 16. 2016.
In March 2016, we repaired the machine. In March 2016, hand over the possession to the complainant.
This case is of 2016.
Yes. After the expiry of warranty period, the machine was purchased in 2013.
Whether the complaint was filed after you have repaired the vehicle?
Yes.
Yes, they have repaired the vehicle, but
Thereafter they have
not
filed
worked out.
complaint.
सर तांकर गोटे
We have filed service report.
टेक्निकल रिपोर्ट देइछथि आ गोटे एग्रीकल्चर वाला भी ऑफिस वाला भी रिपोर्ट देले सर ऑरिजिनल डॉक्यूमेंट भी फाइल आज्ञा सर वारंटी पीरियड नहीं वारंटी पीरियड भितर पर हम कंप्लेन करछु जेतेबेले किनलु तापर फिर फ्यूल सर्वे आम से कहलु वारंटी पीरियड सब वारंटी पीरियड आज्ञा 1/11/13 तापर आम तो से 5/11/13 भी कंप्लेन कर वारंटी पीरियड का से माने कहते हैं वारंटी पीरियड होची वर्ष ना केते हम वारंटी पीरियड देना वारंटी सर 1 year
6 months, only 6 months.
6 months भीतर भी सर
6
months भीतर ताको कथा अनुसार 6 months
फिर 500 है working.
You have got a meter in there.
Yes. Last repairing हेतला 5/3/2016. 5/3/2016. Yes, we have filed in our objection. He satisfied and put their signature in annex B/1. Yes. Start for page 12. Yes. Start for page 12. Yes.
सर हमें प्रिंट 1/11/13 ये 13
Page 25 in last column he put his signature. In bottom.
After that also there is again defects found. Say solid.
Yes.
Sir, sure, sir. Sir, किन्हीं दिनों तो it started defective. सेटा कंटिन्यू करके चल ताको हम देखिलु सी भी देले तापर भी डिफेक्ट पड़ला तापर सर एग्रीकल्चर वाला नहीं सर कंटिन्यू करछि ताको डिफेक्ट सर मु आपको डेट नहीं
My home is after season of crop season he made a complaint.
ना से तो तन इंश्योरेंस कोन बर्तन त हार्ट अटैक भाटे से सुसाइड कर जाता ताको गवर्नमेंट सर सर अपन डॉक्यूमेंट अच्छा अपन की देखो काई नहीं देखो अपन शुणु तापर भी डिफेक्ट बाहरला कौन करिया तापर भी डिफेक्ट बाहर जी कौन करिया आज्ञा
नहीं complaint
कहछु सर शुणु तापर सर ताको मेकानिक 21/6/21/5/16 रे आस्थिले एटा फाइल करछि से लिखिले ये इट इज माय ओपिनियन the above machine is otherwise the mentioned error can create the machine is not in working condition, therefore he has to face several problems. ସେଇଟା ଆମେ ସାର୍ ଯେତେବେଳେ ମୋର ୱାରେଣ୍ଟ ପିରିୟଡ଼ ଗଲା ସୁଦ୍ଧା ବି ମୁଁ ତାକୁ ନେଇ ଦେଖେଇଲି ସେମାନେ ତାଙ୍କର ଏଗ୍ରିକଲଚର ବାଲା କହିଲା ପରେ ସେମାନେ ଆସିକି ଦେଖିଲେ ଦେଖିକିରି ଦିସ୍ ଇଜ୍ ଦେୟାର ଓପିନିଅନ୍ ତାଙ୍କୁ ଆଜ୍ଞା स्टाटस एक मेसीन अच्छी स्टाटस मेसीनटा अच्छी गवर्नमेंट पाखे जो से मैंने किसी कले आम गवर्नमेंट थ्रू आम गवर्नमेंट आज्ञा आफ्टर लॉन्च ये सर वैकेशन भल सर आफ्टर वैकेशन काइंडली आफ्टर वैकेशन
आज्ञा
गाड़ी सर शुणु सर गाड़ीटा
फाइल कर 50,000 टंकार गोटे चेक देले पुणी बैंक को लिखिदेले एनकैश करो ना आम से बाबद गोटे भुवनेश्वर डिवीजन कोर्ट गोटे कंप्लेन प्रायर टू वैकेशन
आफ्टर वैकेशन मैं
प्रायर वैकेशन प्रायर ये 18 तारीख 19 सॉरी सर 20 तारीख में
सर आफ्टर वैकेशन समर वैकेशन
16 मसीह
मोर तो लॉस तो हमर कोन लाभ अछि
लॉस कोन
16 मसीह कोन
लॉस कोन हमें अन्य किसी
आज्ञा शुणु सर नहीं सर शुणु मैं डॉक्यूमेंट जो देछि आपन काइंडली देखिबे से डॉक्यूमेंट गवर्नमेंट आल्सो इंटरफियर गवर्नमेंट को देले गवर्नमेंट तक लिख ले चिट करना गवर्नमेंट को जणेलु आमे गवर्नमेंट को जणेलु वारंटी पीरियड से हमको वारंटी किसी मिलू ना हम कंटिन्यू करके चलछु तक दे दी जाउछु से रिपेयर करके जाउछु आता से गरीब लोग से तो लोग
और
बैंक रू फाइनेंस पाइला बोली बैंक बैंक नहीं गला चलो नहीं नहीं से बैंक फाइनेंस दैट एग्रीकल्चर फाइनेंस पाइला बोली से गवर्नमेंट सब्सिडी पाइला बोली से केस कर नहीं नहीं सुनो सेटा मोर सर कहर था नहीं एक्सपोर्ट पर कहले सर एक्सपोर्ट रिपोर्ट दी सी होची बैंक ये कंपनी रा
कहीं से कागज पेन
सुनो नहीं नहीं नाम तक सामान हो सर से अशोक पात्र सर्विस टेक्नीशियन ताकर आपन पाक आशा पूर्व सब हो जाई तापर एग्रीकल्चर वाला को तापर एग्जीक्यूटिव इंजीनियर गवर्नमेंट सब्सिडी ले हम गवर्नमेंट रखते नहीं मेसिन नहीं माने कोन मेसिन सिम रखी दिया ता पाखरे कोन से कोन ताको हम हैंड ओवर कर दे जा मेसिन हमें जगह ना हम कोटे जगह रखी सर आफ्टर लॉन्च ये वेकेशन को आफ्टर वेकेशन भलो
अरे बिफोर
पूरे छः
जीएमटी धान सीजन सरी जो उडा कंप्लेन कर दे मो वैसनी
नहीं सेमिति गप डोंट टेल स्टोरी कोर्ट इज नॉट देयर टू लिसन योर स्टोरी डोंट टेल एनी स्टोरी स्टोरीज आर नॉट हियर टू से स्टोरीज विल टेल इन अदर
मोर आगे हमरा कौन जो कॉपीटा देबे आज फाइल चले
कैन यू रिपेयर द
नो
रिपेयरिंग स्टेज नहीं
हम से स्टेज भी नहीं हम
बारंबार जाईगिरी करिगिरी किछि नहीं
डिग्री Yes, we have given the service. At this center, the same type of machine we have not sold in Odisha. We have closed the said machine in Odisha. ଆଉ ତ ନାହିଁ ଆମର କମ୍ପ୍ଲେନ୍ କିଛି ନାହିଁ ଆଉ ସରି ଏଇ ଯେଉଁ ମେସିନ୍ ବାବଦ କେବଳ ଆମର ପାୱାର ଟିଲର ଏବେ ଓଡ଼ିଶାରେ ଚାଲିଛି ନହେଲେ ଆଉ କୌଣସି ଆଜ୍ଞା 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 ୱାରେଣ୍ଟି ପରେ ବି ଆମେ ଦେଇଛୁ ସର୍ଭିସ୍ ଦେଲା ପରେ ସେ ये करी मैंने पेपर पब्लिशन करी मंत्री एमएलए कटिकी जाई से जबरदस्त से मेसीन कंडीशन भी ना सजारिया भाया कंडीशन खरा काकर रखिक से पूरा जाइए रिसेंट फोटो
spend that much of money, you are bound to provide that service. They are saying that no, we cannot provide the service.
No, we cannot provide service. I cannot say.
How much is the estimation?
धान कटा मेसिन आठ दस आज्ञा चेन वाला ये आमर से किसी काम कर कारण खरा वर्ष लाइफ क्या अच्छी कि नहीं से मेसिन से जो प्रॉब्लम से मेसिन
ନାଇଁ ସାର୍
ସେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅଫିସ ଆଗରେ କ'ଣ
ଯାଇଥିଲେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଥ୍ରୁରେ
ସେ
ଯାଇଥିଲେ
ମେସିନ୍ ଅଛି କି ନାହିଁ
ଅଛି
ସନ୍ଦେହ
ଅଛି ମେସିନ୍ ଅଛି ମେସିନ୍ ତାଙ୍କ କ୍ୟାମ୍ପସ୍ ହଁ ତାଙ୍କ କ୍ୟାମ୍ପସ୍ରେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କ୍ୟାମ୍ପସ୍ ଭିତରେ ଅଛି ଅଫିସ୍ କ୍ୟାମ୍ପସ୍ ଭିତରେ ଆଜ୍ଞା
26 for hearing. Item 10.
ଆଜ୍ଞା ସେ ତାଙ୍କ ମେସିନ୍ ମିଳୁନି ମଝିରେ ପାର୍ଟସ୍ ମିଳିଲାନି ଆଜ୍ଞା ମଝିରେ ଏ ମେସିନ୍ର ପାର୍ଟସ୍ ମିଳିଲାନି ତାଙ୍କର ପାର୍ଟସ୍ ବି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଓଡ଼ିଶାରେ ମିଳିଲାନି ଆଜ୍ଞା ହଁ ନା ନା ସାର୍ ସେ ସାର୍ ମେସିନ୍
ତାପରେ ଆମେ ଯାଇଥିଲୁ ସଜରେ ଯେଉଁ 2016 ଯେଉଁ ସଜରାକୁ ଯାଇଥିଲୁ ଗୋଟେ ପାର୍ଟସ୍ ଲାଗିଲା ତାର ଦାମ ହେଉଛି 50,000 କଷ୍ଟ ହି ଏଗ୍ରି ଟୁ ପେ ଆଣ୍ଡ ସାଇନ୍ ଇନ୍ ଚେକ୍ thereafter he wrote a letter to bank not to disburse the amount in favor of the company. We have filed a complaint case before EDGM court. We cannot receive the money. Again, we have filed a complaint case, defamation case. Yes. Yes. No, not check. 420 defamation. Because of his character, his attitude.
Item number 10.
କମ୍ପ୍ରେନ୍ସ ହେଇଯିବ
Yeah, I don't know. Lordship, item 12, my lord, for the appellant, the last occasion I filed my authorization letter. Here in this case, my lord, the appellant is challenging order dated 11/12/2019 passed by the London District Consumer Redressal Forum, forward, my lord. And the said order, the London Court will open that there is deficiency in service and irregularity. But the order itself is confusing and contradictory, Your Lordship. Because, my lord, the respondent, yes, Lordship, you've been order in page, Your Lordship, that is in page. Last page, my lord. Page 51. No, 51, Your Lordship. My affiliate is 51. The allegation of my lord, deficiency in service and unfair trade practice. for the fact remaining that the complainant, here is the respondent is the branch manager of the said company manager. Against insurance policy, three insurance policy has been proposed by the complainant and that has been accepted by the company. That is at page, your lordship kindly have a glance. That is insurance ଟା ତାଙ୍କ ଝିଅ ପାଇଁ ସେ କରିଥିଲେ ଗୋଟେ ଟର୍ମ ପଲିସି 20 years ଟର୍ମ ପଲିସି ଗୋଟେ କରିଥିଲେ ମାଇଲର yes defaulter ହେଲେ after payment of 4 installment thereafter reminder and no 4 quarterly yes half yearly for continuous 2 years they have paid. Thereafter, all of a sudden, without any information, though reminder has been given time to time, he became silent. Then the policy became terminated as per the term condition. That is the fact. There, yes, my lord. 30 days. That the appeal is within time. Appeal is within time. Yeah. But there is lapse of my lord 3 months. After yes, he became silent for 3 months. Then thereafter he sent a pleasure notice. No, 3 months, your lord. But the term condition, as per to the term condition of the insurance company, that is within 30 days they should be pay the premium with fine. With fine, but that is also not done by the complainant. And all of a sudden, they write that there is no reminder. What is the limit? It is not properly feasible the term condition, but 30 days. So for my instruction. Thereafter, yes. Taking the premium lordship, but against after all of a sudden he became stop the payment. My lord. Because it is against the section 64 BB of Insurance Act 1938. It is asserted in the form that wherein it has been specifically mentioned that risks will be assumed by the insurer only when premium payable is received from the insured. However, the learned no, this is not a claim on this. But he is also not subtended sufficient cause. Why became silence for? Because he himself is a staff of the company. He is very much aware. What is the order? The order is at 51. You lordship.
The discounted amount of premium with the prevalent rate of penal interest from the complainant provides the state policy to obtain within 30 days of receipt of the order, and the complainant is also directed to pay the rest of the discounted amount of premium within 3 months in 3 installments with the prescribed rate of penalty on the amount from the date of receipt of this order or else law will take it. Forget about the language, but what is the, how you are visualizing if it is right?
Because prior to that matter, he is a regular defaulter of payment. In between, my lord, the execution case has been proceeding and warrant has been issued. That is why I filed I, your lordship. And further,
Somebody goes for insurance for protection. Whatever provision you are looking at, always premium is to be paid in advance. 64 days.
my lord.
If I
Again.
have not paid the premium, naturally I am not covered. So if I am not paying the premium, I am not paying the premium, I am naturally not protected.
Deprived, yes.
If I default to pay the premium, even during the grace period, the policy lapses.
Yes, your lordship.
So only during the grace period, I am covered because at the grace given by the court. Here in this case, somebody has not been able to pay.
Prior to that, he also chronic defaulter, your lordship. That is also there in the record.
ଆପଣଙ୍କର ଯଦି ଇନ୍ସୁରାନ୍ସକୁ ଆପଣଙ୍କର ଫାଇନାନ୍ସିଆଲ ତ ସମାନ କରୁଛନ୍ତି I pay, I get protected. I don't pay, I am not protected.
Exactly.
Very simple. So in this case, he has defaulted in paying the premium. So naturally, he is not protected. He is not having the umbrella right now.
Right.
But since somebody has paid the premium or rather entered into the contract long time back, he may be benefited, rather see, in this case the daughter is there. She may be benefited so far as the premium is concerned. Because if a new policy is taken, what is the age of the insured right now?
Only 5.
What is the age of the insured right now?
Right now, by that time, he is 5 years old.
There was 5 years. Term insurance.
Again, term insurance.
After term insurance.
No, no. It is, the insurance detail is there. Lordship. In the proposal form, kindly have a glance at page
What
42.
is the date of entry into the contract?
Written note along with the date chart, your lordship, because numbers of date is also required to proper adjudication. But when I am praying for the addiction, maybe kindly stay, my lord. Forward again. My lord, oblige, my lord.
Item number 13. Item 14.
छोटी वैकेशन वैकेशन नहीं
This for the respondent and for the applicant. They constantly have vacation for a vacation.
the finance ନେଇଥିଲା auto rickshaw ଟା that was possibly seized and sold to third person in spite of direction without notice in spite of direction of the district forum for payment of 20,000 and release of the auto. And auto was sold without any notice.
I did this as a report the ତଳ ଅର୍ଡ଼ର ହେଇଛି ତାଙ୍କୁ ଅଟୋ ରିକ୍ସା ପଇସା ଫେରିବା ପାଇଁ ଆଉ କମ୍ପନସେସନ୍ ଦେବା ପାଇଁ ଅଟୋକେ ସାମେ ରିପର୍ଚେସ୍ କରି ବିକିଦେଲୁ
ପଇସା ଫେରାଇବା ପାଇଁ ଅର୍ଡର ହେଇଛି
with compensation. ହଁ ସାର୍ ବିକ୍ରି
ବିକ୍ରି ହେଇଗଲାଣି 13/4/21 Inspector of Direction of the District Forum. Refund of the amount he had already paid for installment.
EMI ପଡ଼ିଲା 50,000 ଟଙ୍କା
EMI 3ଟା ଥିଲା ସିଜ କରିକି
ଛୁଟି କଲା ସାର୍ ଏଗ୍ରିମେଣ୍ଟ ଅନୁସାରେ ସାର୍
People like you are legal advisors. We expected the.
डिस्ट्रिक्ट फॉर्म काम पड़ जाती है क्या भी नहीं डिस्ट्रिक्ट फॉर्म काम पड़ जाती अगर तो क्या अपना सीधा
We should be graceful.
ना कोरिया का तो नहीं है मुझे क्या होता है
The development is becoming too aggressive.
ठीक है छुट्टी पर
So I also want to bring your attention to the order of the Honorable District Commission. If you can see in my FA number 396 on page 15. I just want your attention to the order of the Honorable District Court, Honorable District Commission, which is there in my FA number 396 on page 15. I just want your attention, sir. Paragraph 6. It says there's no wrong treatment was not given. Treatment was right. The procedure followed also was right. So the question of expert opinion does not come here. So I just want to read the order. Paragraph 6. Dr. Gautam Panda, who conducted the retinal detachment surgery at Kalinga Hospital, had followed the procedure. That is scleral buckling with subretinal fluid drainage in the left eye for retinal detachment, and it is accepted procedure in medical science for the aforesaid surgery. So the commission is agreeing that the correct procedure was followed. The doctor who adopted the approved procedure of surgery cannot be blamed for failure of the treatment. But in the case in hand, the treating surgeon discharged the patient So what is the question here is, after the surgery what happened? The treatment in itself was not wrong. Discharge the patient with a note that the patient was being discharged in a stable condition. The date of discharge was 21st/6/2013. But on 25th/7/2013, the doctor of Kim's Hospital, Bhubaneswar, found that the retina was detached and stiff. The patient had also problems of redness, pain and swelling in her left eye. Certainly, it amounts to deficiency in service. So here does not come the question of expert opinion. Even then, even if the question of the expert opinion comes, the matter was before this honorable commission and the order was passed in 2018. Meaning thereby, when the patient was discharged, she was not in a fit state to be discharged because the operation was not successful. Therefore, the hospital and treating surgeon who discharged the patient with the remark that the patient was stable have suppressed the failure on their part, which also amounts to negligence. Had the doctor and the concerned hospital expressed the truth before the patient, then the patient could have taken immediate steps for better treatment of her left eye. The discharge from the hospital put her under impression that her eye problem was over, but it was not the truth. Even after the surgery, she had several complaints, which the doctors at Kim's Hospital, Bhubaneswar and Aditya Jyoti Eye Hospital Private Limited, Mumbai, observed at the subsequent stages. Therefore, medical as well as ethical negligence on the part of Dr. Panda and Kalinga Hospital, Bhubaneswar cannot be ruled out. The combined effort of medical...
That is the finding of the district commission.
Yeah.
That is not to see that how they have said that. So this case you are submission that no expert opinion is required.
Yes, it was ordered by this Honorable State Commission. Pardon me?
1 month after the operation, at the time of discharge of the patient, you are okay. For 1 month, the problems come.
After 1 month, no.
After 1 month of the discharge,
May I submit your worksheet if you are.
Date of discharge was on 21st/6.
then when
But my petitioner has gone to the hospital even on 21st/7 and consulted after the discharge. She has 2 to 3 times she has consulted the same doctor and gone to the same hospital. And when she did not get any relief, she has gone to the other hospital, to Kim's on 25th.
how can the submission would be that operation was, immediate operation was wrong, not successful. How the doctor will be taking service?
No, the deficiency service comes here, like because the doctor said that she is discharged in the stable condition, even when the operation was not successful. In spite her going to the
Who
hospital,
will give opinion that at the time of discharge?
to the doctor himself, he would have said that operation is not successful, so she would have been referred to some.
Who will open that? Your doctor.
Dr. Panda should have.
You have filed that document.
Pardon me?
You have filed that document. Doctor Panda document. That is, the operation is not successful.
No, that is what the Dr. Panda has not informed the petitioner or the patient that the operation was not successful, as he has not.
Then he has to be Dr. Panda and to be cross-examined by the medical authorities or the doctors. Other doctors. That has to be cross-examined by Dr. Panda. But the Dr. Panda evidence will be accepted as the medical expert opinion. It is not evidence.
So I am stating the facts. What happened?
You are saying that the discharge was made on 21/6/2013.
Yeah.
And thereafter on 25/7/2013, it was found that the retina was discharged and stayed. So your grievance is that had it been properly conveyed to the patient while discharging, you are not in a stable condition actually. So the operation was not proper. And therefore, this particular thing can be presumed that you are not in the perfect condition. This is
what you want to
Yeah,
say.
yeah. Because in the page, in paragraph 3, on page 11, after discharge of the para 3, the last paragraph, 4 lines. After discharge of the patient, Dr. Panda had undertaken follow-up treatment till 19/7/2013. So even after the operation, which took place in 21st/6, the patient went till 19/7/2013 to the same doctor. But till then, he did not disclose to her that the operation was not okay and she will not be able to see. Had I said this fact was revealed to her, she would have gone for further treatment. But this fact was not revealed to her. Then when still redness was there, she could not see. Pardon me? That was the yeah, that can be examined. No, process of operation is not challenged here. What happened afterwards is challenged.
Here date is 21/6, the date on which you were discharged.
Yeah.
You are saying that even though you were discharged in a stable condition, actually there was something wrong.
Yeah.
A misrepresentation was made by the said doctor. Even the follow-up action was done by the treating doctor. But you came to know only on 22/7.
Yeah.
It seems that something was wrong, that detachment was there.
Yeah.
Had it been properly implemented to you, you would have taken the right.
Take it right. Yes. Yes.
So here you are compared to the discharge certificate given on 21/6. Whether that was done after due verification and examination of your survivors. So we in our considered view, we think that an independent opinion that all safeguards and all safety parameters have been duly evaluated by the treating doctor while judging you were there or not.
Yeah.
What the question is, I don't know 21/6, whether you are discharged in a stable condition or something was wrong. Another test could have been done at that stage. 5 tests were required to be done, only 1 test was done. So an independent doctor should do that. What is your objection?
Yeah. My objection is, I had come to this honorable commission, to the state commission, with the RP case number 64/2018. When the district commission had asked me to go for expert opinion, I had come to this honorable commission, and when I came, the Dr. Panda and Kalinga Hospital was the opposite parties, and there the RP number 64/2018, this honorable commission had given the order, considering the order dated.
What was challenged in that?
It was challenging about the
Expert opinion.
expert opinion was challenged, and on 11/6/2018, this honorable commission ordered that, considering the submission that the treatment records of the doctors who subsequently treated the petitioner or the complainant filed by her constitute expert opinion, on the basis of which petitioner come to know that there was negligence on the part of his OP number 1. We dispose of the revision direction to the district forum to consider the medical treatment records of the doctors who subsequently treated the complainant as expert opinion, and proceed to dispose of the complaint on merit in accordance with law expeditiously. This was the order of this honorable commission. When this honorable commission passes this order needs to be challenged at the appellate. Not in this commission once again. Then we also have to look into CPC number 11, which says one cause of action cannot be.
Cause of action is always found to fact, and appeal is nothing but continuation of the origin of the incident. So don't you think that the ancillary and incidental power is always in the appellate forum? Within the appellate forum, but at that stage, while the district commission was hearing the case, some order was passed, and that was challenged in division. And at that moment, the state commission in its commission, the state said yes, that is all right. But with the re-evaluation of all the evidences are made in the commission, whether the state commission is not having the jurisdiction to send it for export evidence, export opinion rather, I would put it that way. What is wrong there? How are you prejudiced? I am asking this pinpointed question. How are you prejudiced by that?
I am actually not prejudiced.
That may help
But-
you also. Because we would have an independent assessment of the situation. Here we put in the balance in the discharge date that is 21/6. Whether everything was done in accordance with the standard operating. This is what needs to be evaluated.
Yeah, actually, even the district forum does not say that there were any wrong treatment was done in.
Division member actually has you almost you want to say that it is almost like race judicata. This is what you want to say.
Yeah.
That it is almost like race judicata. If at all they were agreed, it is not a question of whether they want export evidence or not. The commission wants that it should be evaluated by an independent person, expert person. So whether that particular final order in the revision would act as res judicata for the present commission at the appellate stage must not to pass that order. Rather, you want to argue in that has been finalized.
Order we are having, but the order was, sir, or impugned order was on the date of admission only. The court has disposed of the matter. This revisional court, this honorable state commission has reversed the matter that whatever document sees showing of two medical documents that may be treated as a medical expert opinion without hearing, without giving notice to the opposite party, because the sir, I mean, on the date of admission in itself.
But if it
RP was arising out of our application filed by the hospital as well as the doctor have filed an application in the court below that in this kind of cases expert opinion is bare necessity for going for any kind of subsequent adjudication. So on that application, the Honorable District Forum has arrived at a conclusion that yes, it is a fit case for going for a expert opinion. Now, the person who is aggrieved, the patient was aggrieved for a medical opinion, and she moved to this forum, and this court, without giving any opportunity of hearing to both the parties, had sent the matter allowing that whatever document you are showing that may be treated as expert opinion.
What was the export evidence what the complainant was trying to rely
Sir,
in her case?
sir.
What was that export evidence?
Sir, two documents. If I put everything on factual aspects, the medical treatment was done on 18/6/2013. The operation was conducted. She is saying that on the very same day, I went to the hospital to the doctor, met the doctor. Doctor has advised after looking up to my conditions that today itself, immediately your treatment is necessary. Otherwise, you will lose your twice. So that is why I got admitted in the hospital. Treatment was done. All the kind of operation was done. Thereafter I was discharged. After 1 year, she has alleged filed the complaint case alleging by giving 2 documents saying that within 1 year I got treatment or I made myself to medical verification before 2 hospitals, one at King's Hospital and again at Aditya Nursing Aditya Bombay. Both the doctors' opinion, if your lordship will see the records, King's Hospital report is not the report of the patient himself. He has given a report of a wrong name of another person's report. If your lordship will kindly see the report first. Second, the opinion which had been given by the Bombay, the Aditya, they had given an opinion so far the retina treatment, but here the hospital, she has got treatment for retina removal. So, we both parties, the hospital as well as the doctor, has prayed before the court that an expert opinion is necessary because all the 2 reports on which she is relying and saying that all the hospital, whatever treatment she has been got is not at par or any kind of deficiencies there. These 2 opinions or medical document should be examined thoroughly. Both the opinions have never been, except filing the reports, neither those persons who have given the report have been examined by the learned court below. Nothing was done. And moreover, interestingly, what I told, if your lordship will kindly see the report, the King's Hospital's report is not of the patients or of the present complainant. It is a report of somebody else. Report has been given. His name.
How such committee of error has merit?
Yes, that is the face of the record that is showing. That is what we have filed this objection of this present appeal.
Madam, is it
Actually,
a fact that the record or the document furnished or
no, it is not of the wrong person. It is.
Sir, King's Hospital's report is in favor of Satyanarayan Patra. He has given a report of a Satyanarayan Patra. The patient's name is Satyanarayan Patra. Satyanarayan Patra. Complainant is. She is Tanulata Mahanti. So all these glaring defects have been pointed out in our written statement as well as at the time of sending the matter for expert opinion. My lord, absolutely. No. If, sir,
what we are trying to do that as of the date of discharge, that is 21/6/2013, and thereafter the re-evaluation after 1 month by Kings, whether they are consistent to each other or not.
yes,
And at the time of discharge, after 21/6, whether it was done after due evaluation or clinical evaluation.
absolutely.
So in such a situation, you are saying that the report of King's is concerned, it relates to a different patient altogether.
Absolutely.
Then how can we have send it to that particular report with 21/6 of the present complainant?
So that is why we prayed that an independent expert.
Examine that as
Yeah, what the
whatever is saying that.
no, what documents I have is of Tanulata
What are you
Mahanti.
relying on? Where is it?
Sir, my paragraph 7, your lordship may see.
No, where is it part of the report?
Record that documents is not. Satyanarayana Patra.
That must have been filed by the complainant only.
But what documents we had? Let's see.
What connection?
Annexure J.
Annexure J देखो हमें नहीं क्यों Annexure J that is what she the complete that is annexure J. Annexure J that is what we did.
There are number of annexures J.
Annexure J, 3 only. 1, 2, 3.
Annexure N.
J.
Annexure J.
J.
Yeah.
ସେ ରିଜେଣ୍ଡରେ ସେ ଦେଇଛନ୍ତି
The impugned order is silent about any annexure. ସେ ଖାଲି କହୁଛନ୍ତି ଯେ
ସାର୍ ଯେଉଁଟା ଡିସ୍ପ୍ୟୁଟ୍ କରୁଛନ୍ତି ଯେଉଁ ଆନେକ୍ସରଟାକୁ ସେଇ ଆନେକ୍ସରଟା ମୁଁ କିମ୍ସର ସାର୍ ସେ ସବୁ ଗୁଡ଼ାକ ସାର୍ ଏଇଟା ରିପୋର୍ଟ ହିଁ ଅଛି ମାନେ ଷ୍ଟାର୍ଟିଂ ଟୁ ଏଣ୍ଡିଂ ଆଜ୍ଞା ଏଇଟା କିମ୍ସର ସାର୍ ତାପରେ ଅଛି ସାର୍ ଆଦିତ୍ୟ ଜ୍ୟୋତିର ବି ଅଛି ତା ସେଇଥିରେ ସାର୍ କିଛି ଲେଖା ନାହିଁ ସେମିତି
ऑपरेशन भूल अच्छी नहीं
डॉक्यूमेंट पाऊनी
are discharged on 21 days. And the follow-up treatment was also done by Dr. Panda till
1970.
21 or something like that.
1970, yes.
And thereafter you went to kids.
Yeah.
And thereafter you went for cataract surgery. Right?
Yeah.
So your allegation is that after the opinion of the doctor at kids, you came to know that the retina was not rather detached. Right?
Yeah, detached and stuff.
So that the presumption would be that there was something wrong at the time of discharge. It was not in a stable condition, but it has been proved to be in a stable condition.
Yeah.
So at this juncture, you came in revision here. And since that order is there, you are saying that at this juncture, sending for an expert opinion is barred. Are you saying barred or you are saying something else?
Yeah.
It is not necessary, or it should not be.
Yeah, it is unnecessary, exactly. I mean, because
Whether we are bereft of power to send
it is your discretion. It is your discretion.
We are asking you very point blank.
It is
Whether we
the
are having
it is the description of this honorable commission.
Then why are if we are thinking that okay, this may be the interest of the state?
Because
it is actually an incident for due adjudication. But
my main concern is in 2018 the order was passed by this honorable commission regarding the expert opinion. Now again to go through this in 2018, if they were agreed by that,
how is the patient right?
pardon me,
How is the patient right?
patient's right.
How is the patient right now?
My patient is unable to see, and somebody has to be take her around. Always somebody has to be there.
That left eye.
Yeah.
What about the right eye?
Right eye also is she can see little, very little, but she is not unable to. But if she has to do something and all, somebody has to be there. Also.
What is your age right now?
She is 77 or something.
So you were 70 plus at the time of operation.
Yeah. Now she is 72. She is 72 now. Operation happened in 2013. That is 7 years. 10 years back. 62 she was.
The two orders are extremely important so far the learning court forum is concerned. One is on 7/9/2015 and another is the order being agreed by which the revision was signed, and the revision itself, the record, is also necessary for for ends of justice for adjudication. That revision application and that record is necessary for final disposal of this case. Yes sir. Sir, সেই অর্ডারটা যেটা সেই অর্ডারটা হচ্ছে 2/5/18 yes 2/5/2018 the London Council for both the sides are present. ମୁଁ କହୁଛି ସେଇଟା ଆସୁ
And also kindly, you don't have any objection whether you want that it should be instead.
yes, if at all she is entitled or any kind of foul play or any kind of medical negligence has been done, it should have been brought out. But thing is that you cannot today we have got examined or got the medical treatment from one doctor. After 1 year, I will go to another doctor. He will advise me that prior to 1 year, whatever medical checkup or follow-ups you have taken from another person, it is a wrong doctor.
But it is, yeah.
No, 2014 it has filed the complaint case. Sir.
But 21/6 is the date of discharge, and in the month of July, different doctors give different
No, no.
report advice.
Yes.
Nothing more than that.
Sir, we are saying,
I think nothing more can be done. Only the evaluation that the treating doctor or the operating doctor, while at the time of discharge, has taken all precautions, including post-operative advices.
For the date of admission to the research, the document you should tell them for the other is good well.
Are you visualized? Madam, you are seriously objecting to for expert opinion.
Yeah, because in the order it is never said that the procedure is wrong.
Nobody is going for the procedure.
Yeah, neither the treatment, wrong treatment is given, it is not said. So expert opinion we need when the treatment is wrong.
You got operated on 18/6.
Yeah.
Discharged on 21/6. Giving post-operative advices for almost 1 month.
Yeah.
And thereafter you have been treated by another doctor in another hospital.
Yeah.
Right? So this 1 month document is crucial. Whether that has been done as per the standard operating procedure and whether any culpability can be attributable to the doctor who has operated and advised you post-operation. I think this is what is to be working.
Yeah.
Nothing more than that.
ତଳ କୋର୍ଟରେ ମଧ୍ୟ ସେଇ ଯୋଉ ଦି ଜଣ ଯାକ ଦେଲେ ପୋଷ୍ଟ ଆଡଭାଇସ୍ ଯେ ପ୍ରିଭିୟସ୍ ୱାନ୍ ୱାଜ୍ ରଙ୍ଗ ସେମାନଙ୍କୁ ଦି ଜଣ ଯଦି ଏକ୍ସାମିନ୍ କିଛି ଆଣି ପ୍ରଡ୍ୟୁସ୍ କରିଥାନ୍ତେ ଯେ ଆମେ ଓପିନିଅନ୍ ଦେଲୁ ଆପଣ ଡକ୍ଟର କ୍ୟାନ୍ ଆସ୍କ ଏନି କ୍ୱେଶ୍ଚିନ୍ସ that on which basis you have given this kind of wrong treatment and report that the earlier one was wrong. If seman ଦି ଜଣଙ୍କୁ ବି examine କରାଇଥିଲା only on the basis of their report the learned forum below has passed the order.
No. Even the forum below. If, excuse me, sir. I just want to, sir. Sir, 1 minute. In page number 14 of the order, it also says that before going into that question as to whether Dr. Panda was negligent or not, it is tries to see the complication associated with the retinal detachment surgery. They also are listing here below what are the side effects of retinal.
You are reading the input order or not?
If in order.
That is on the challenge.
Yeah, that's on the challenge.
Challenge that. That order has been passed wrongly, they have challenged that.
We are challenging on both the doctors who are subsequently giving their reports. We are challenging their veracity of the reports. So now who can determine, your lordship can determine. Sir, revision ta asu record ta tapore sir. Sir. ତିନୋଟି ଜିନିଷ ସାର୍ ଆମ ଡିସଚାର୍ଜ ସମୟରେ ତାଙ୍କର ଯୋଉ ସବସିକ୍ୱେଣ୍ଟ କିମ୍ସ ର ଗୋଟେ
Madam,
30th September.
11/6/2018.
11/6.
RP 64 of 2011. 54 होगा July 1st week. July 1st week.
medical negligence cases should be very serious. Don't remain up.
No, sir. I will.
So therefore, we want a convenient date for all the parties.
How such
It has gone in the ethical manner. The evaluation, it is never preponderance of probability in medical negligence. It is proved here medical on doubt. So has gone more ethical design literacy and all those things. This is what the order says. So how far that can be sustainable? That we have to skip.
5th of July.
Madam, there was a-
Yeah, 5th of July, yes. Yeah.
15.
Very bad. Some take that is equal to considered amendment. I can take today file amendment. Oh, like. Again? First it.
Sir, I have item 15, sir.
And next year hearing on.
Sir, item 15, 1 5. Sir, I'm on behalf of Mr. Nayak, PN. I'm supposed to submit this affidavit. I'm the respondent, sir. Applicant.
Item 15, 1/5.
1 5, sir. No, I'm on behalf of
15 for what is the case number?
one double line, sir. FA number 992023. Sir, we request for a adjournment, sir. Huh? I couldn't follow you, sir. I am supposed to submit the affidavit. I was told. Huh? No, not there.
I was asking the question whether notice against the respondent was sufficient or not.
Can I pass on the message to him? I'm sorry, sir. He's not there.
Item number
16, sir.
Same order.
Sir, I'm supposed to read the affidavit. Item number 18 and 19.
Item 17.
Date तक मिलेगा?
Item 17. If you such choices, RL Patnaik and associate. RL Patnaik and associate. Virendra
respondent by appeal to
17. Paper after vacation filing the written note of submission.
Sir,
18 and 19.
Paper after vacation filing the written note of submission.
Date तक है भाई
Virendra Mohan Nair.
15, 16. तो दे पढ़ ले दे
Virendra respondent. RL Putnam access.
कितना नंबर 251
18.
हाँ सर हाँ सर 7 affidavit
28. Item 20.
सर डेट कब है नहीं
Item 20, I am appearing from respondent number 1 and 2.
I am for the appellant.
1 and 2. One to pay
Again?
9
3
RTO 3.
RTO option 3. Daddy, I'm
Cardi is not the issue. Issue is they are saying we have taken, they have purchased a Unicum bike from my company. They are saying I have taken 1371 excess amount. I shall counter to that.
There is the date of price. Notice has been issued on limitation as well as appeal. Also, okay, नहीं उसमें लगेज नहीं सर, हाँ सर, आगे, ठीक है.
23.
23. Actually, I could not able to get my file. Actually, somewhere it is being misplaced. I am for the appellant.
I am for the respondent. I am to file my written note of submission some more time.
Who blessed?
On the appellant, there has been delay of about 98 days. And another IA has been filed for stay for issue of the notice. बात करें कि वो तला वैसे तापरे ये नोटिस ठीक है टुडे और ये नेशनल स्टे इंक्लूजन Sir, आज दिल्ली में कॉलेज तो 7 तारीख देला आज रखले आज कहते करी काली काली को पिटूरिया पिटूर मतलब देखी पड़ो कोरापुट जयपुर असुविधा फाइल मेसेज को स्टे एग्जीक्यूट तो फाइल ILO में 19 of 24 बहुत सारे जयपुर स्टेट है ये सर ये बात का स्कूल कॉलेज में टीचर क्या कॉलेज सर दिल्ली कौन
Sir, I have to deposit some more affidavits. 45, 46. Should I? I have to go to High Court. 45, 46, 47. 44, 42, 42, 43, 44, 45. Last 4. I have to wait. Very kind of you, sir. Thank you, sir.
Notice has been issued on last occasion on 8 April sometime. Same.
Appellant. And final application to set aside the ex parte order and I filed my application. My it was rejected. Hundred 4 days. 104 days. I got
10,000. Same are 3.
We are very consistent in that. But the inconvenience is to be solved on our side. We think that 100 rupees per day will sufficiently compensate the other. We have been trying to be consistent in that.
5,000. 10,000 is too much. But actually, the petitioner was hospitalized, for which I could not file the WS in time. I filed an application to CNS.
Limitation is concerned, right?
Ma'am.
It is nothing but combination of limitation. I got set of mind. So once the limitation period is over, the other side, they write back to 2017. That is for putting the clock back. For that, the other side has fully compensated. But the inconvenience will be lost to him. He should have been very comfortable. Now again you are putting the clock back to do that. So for that, for the 100 rupees. That is what we have been maintaining. So if you are ready, fine. If you are not ready, we can go to the, we are not going to admit the case.
Arshal, that.
Now we are consistent. We are consistent. You are appealing to the other side.
I'm for yes, madam. Notice फेरी आसी है. Now, direct cycle. No, other thing not. 2 o'clock division bench is breaking a lordship at 3 bail matters. Lordship can have some other day. I think lordship direct. I don't know. You have lordship. LCI be called for a lordship.
2 weeks time to pay. But I may be pardoned. Item 26 I am appearing for the respondent. Item 26.
सर 26 जोटा गला आप कहते थे 30 दिन है नहीं आउ दिन रखिले से अपियर करथुनी बोथ द रेस्पोंडेंट पे देयर आर 2 रेस्पोंडेंट 1 2 पे मिस्टर इनके दास है नोटिस ऑफ फिल है डीएफआर में भी कौन
So 27 I have a first day of the other proceeding. Madam.
Complete this formality of paying the law.
CRP called for.
Item 29.
besides 35, this court has jurisdiction to entertain on 49 2. I am reading 49. Procedure applicable to State Commission. The provisions related to complaint under section 35, 36, 37, 38, 39 shall in such modification as may be necessary be applicable to the disposal of complaint by the State Commission. 2. Without prejudice to the provisions of section 1, the State Commission may also declare any term of contract which is unfair to any consumer to be null and void. Here 35. Let us read 35. 35. District Commission has got jurisdiction also. 35. Under 34, jurisdiction District Commission starts. 35. Manner in which complaint shall be made. A complaint in relation to any goods sold, delivered, or agreed to sold, or delivered, or any service provided, or agreed to provide, may file with the District Commission. Roman 2. I am not coming on others. A consumer who alleges unfair trade practice in respect of such goods or service. So, State Commission, District Commission has got jurisdiction. Besides that, State Commission can entertain under section 49, subsection 2. That is my stand. What they do by the State Commission with the prejudice to the provisions of section subsection 1, subsection 1 of 49, where 35, 36 and process. The State Commission may also declare in a term of contract which peculiar jurisdiction. They are also in 49. They hold whatever jurisdiction exercised by the District Commission under section 35 can also be dealt by State Commission under this section. Jurisdiction subsection 2, 47 2, as you are under on the last occasion, complaint against unfair contract where the value of the goods or service paid as concession does not exist. So here it has been mentioned paid, but there 49 nothing has been mentioned. State Commission on its own motion, in respect of even if District Commission has got jurisdiction, can also entertain the application and decide the matter and declare the term of contract unfair.
Irrespective of valuation.
Yes. No, it is without irrespective of valuation that.
That means there is no pecuniary jurisdiction so far as 49 is concerned. That is what you are talking. That is nothing enabling provision. So, what is your prayer in the complaint?
My complaint is
What are you prayed for in the complaint?
they have within a short span, within under section 5, grant compensation and direct the opposite party shall pay amount of rupees to calculated in para 10 above, and further direct the opposite party shall pay penal interest of complaint 18% above amount. Pass such other order, direction will be given. So they are my humble submission. My residential building is cost more than 1 crore, and they have granted 64 lakhs. Suddenly they, in the month of December, they say you have got overdue installment 1,63,000.
In view of the facts stated above, the complainant only claims that the commission which judges is being direct and the opposing parties are paying the amount of subject as per paragraph 10 above, and order direct and the opposing parties are paying payment by interest complainant at the rate of 18% per annum. Pass of forward order are direction and the opposing
That is third clause C is coming under that declaration. Yes. Though it has not mentioned clearly, pass such other orders.
Can we presume that
Because as it apparent from the record, the agreement, they have flouted their agreement. The 24 months is still due as per the annexure.
Where have you made that prayer and abundance to that effect, that it is not falling under 47.1A1, rather it is falling under 47.1A2. Have you made out a case?
No, that I
have not made it in that way. On their contract has to be specifically detailed in that way, and also the prayer has to be couched in that language only. Have you done that?
I had not.
Done that.
No. And there also, if what your honor is suggesting, there also it is mentioned less than 1 CR. They have not made minimum 50 lakhs. Less than 1 CR. 50 lakhs to age 21 re. 1 CR to 50 lakhs age. Less than 1 CR. आज्ञा आज्ञा शुणी तो हमनी this disputed value of the proceeding, valuation of the proceeding is more than 50 lakhs.
Valuation cannot be taken into consideration. Valuation that if you look at 1986 Act, amount claimed is the key word.
Yes.
Here the key word is consideration paid.
Paid.
So there is a big difference between these two, as per our understanding. Consideration paid.
Paid.
And previously it was
I'm not claim.
So as per our claim, it is all right so far as the prayer is concerned.
Yes.
But that cannot be the yardstick to bring in jurisdiction so far as the state commission is concerned. Here we have to satisfy as per the prayer and feelings that the consideration paid is more than 50 lakhs and less than 2 crores.
Now I admit you have not paid that much of interest. You have not paid that much of interest. Hardly we have paid 22, as my instruction is 22 lakhs interest they have paid.
How can we
Then your lordship, what honor can pass an order, I will approach the district forum. I will approach the district forum. And on the event of filing, the matter shall be taken up expeditions, that order can be passed. That order can pass. I will immediately pass. Tomorrow, I have instructed my client. Tomorrow, they will approach there. And
you withdraw that to the liberty, just give a memo.
I will give a.
Give a memo.
Yes. केन्द्रापड़ा हो केन्द्रापड़ा हम कटक मुझे जानी हो केन्द्रापड़ा कम्प्लेट केन्द्रापड़ा टाउन I am submitting memo. नहीं लिमिटेशन नहीं भी इमिडिएटली पास है ऑर्डर जनवरी पास है से ऑर्डरटा जनवरी पास कले तेणु से जो क्लेम नोटिसटा 806 फेब्रुआरी गोटे 19/12 फाइल करते पास करते 13 फेब्रुआरी 24 रे पास आज्ञा 13 फेब्रुआरी 13 फेब्रुआरी କେନ୍ଦ୍ରାପଡ଼ା ଆଜ୍ଞା।
Why Keନ୍ଦ୍ରାପଡ଼ା? Why should we write that? Because ଆପଣ district commission appropriate that discussion is your part of
that dispose of dismiss ଜାଗାରେ dispose of ଲେଖିଦେଲେ better
withdraw.
hey, on the event of district commission is at liberty to take up this matter as it ସେଇଟା I'm sorry. दो
I am for the respondent number 1. I am for the complaint. Respondent number 1. First case. SP 10 for appellant in first case, second case Mr. DP Shodham. Previously, Lordship has heard this matter. The complainant applied for a loan to purchase a Bolero vehicle. Subsequently, that was accordingly three quotations here filed. One specific allegation is the one of the Sapna motors that is being persuaded by the Sundargarh. Sapna the petty. Statement. Draft. Proprietor Sapna Motors. What is that? Bolero. Including समस्त फाइल करछन लेटर नोट ऑफ सबमिशन हाईकोर्ट बारे बसुँ ଦରକାର ମୁଁ ଦେଖିବି ଯଦି ଆଜି ପାଇବି ତ
Have you got the court of notice copy of the number? देखने कौन सी बात डेरा स्टोर में एक्टिविटी को फाइल करें जोड़ा नोटिस से स्टाम्प लगी तो जो गुजार अच्छी बात है तो डेरा स्टोर में एक्टिविटी को फाइल करें hard copy is available. Copy नहीं होगा. hard पड़ोसी का काम करो. hard copy अच्छी. अपन को copy अच्छी. अपन को जाके extra फाइल नहीं होगा.
In this case, and for the respondent, your Lordship has directed the appellant to produce the document as to why they have appointed second surveyor despite their first surveyor.
There is no such provision to appoint second surveyor or third surveyor. Really, first surveyor is appointed for spot survey. When any accident occurred, immediately we depute a surveyor to inspect the vehicle. Really, what really any accident occurred or any damage has been caused. Subsequently, really we deputed after dismantle of the vehicle, we deputed a surveyor. That is the final surveyor, and re-inspection surveyor is appointed only to re-inspect whether that parts have been substituted or not. That parts have been really placed or not in that particular vehicle. There is no concept. Second floor नहीं re-inspection करने second floor पर क्या ना she again second floor का re-assessment करेगा हम क्या पता नहीं कहीं करा जाए ना जो प्रथम जे देखिला assessment कर देना से जो assessment करा सेटा प्रकृत सेटा के replace कर चिला नहीं पार्ट्स उड़ा exactly अच्छा अच्छा हाँ बिल्कुल ताले मतलब सब गुड़ा तरह से लाइट गोटे फ्लैग मार्क करके गोटे पेज कर दूची कर दी बेटर सर जी से दिन बेस्ट हो दैट विल टेक टाइम ना हम रखे पे हां अपडेट से
appointments, outcomes of appointment, and also the scope of their work. And we can never be turned down.
Second survey, third survey, yes, exactly. Exactly, that is my okay. For purpose of, sir.
Yes.
Question of second or third concept does not have.
They themselves in their written statement have admitted that first surveyor was appointed and thereafter final surveyor was appointed. And Honorable Supreme Court has stated that, held that second surveyor.
Surveyor appointment is 64 UN, right? So he is saying it is not falling into that category. Only one person is appointed on the 64 UN, right?
Exactly. That is my
If as per the evidence available, it is found that he has appointed repeated surveyor.
To reevaluate that particular assessment, then second surveyor. Exactly.
That be an abuse of power.
Yes, we have not evaluated the assessment made by the first surveyor. I mean, can question of
first surveyor calculated 6 lakhs. Then second surveyor are reduced to 2 lakhs without assigning any result.
I am clarifying the position. First surveyor is a spot जे कहबे कि इमीडिएटली प्रकृत घटना घटछि ना नै सेतले से हम टेलीफोन करी कहि देले हम से पळै लागे से कहला जे हां प्रकृत एक्सीडेंट घटिछि से जो कहउछन फाइनल सर्वर हम आगे करछ इंजीनियर आरसी पटना से असेसमेंट कर देला असेसमेंट करतला परे आमे आ गोटे सर्वे कलु जे जो आरसी पटना जोटा कले सेटा प्रकृत असेसमेंट जोटा करछन्ती ठीक कि नाही एति करछु ए जो 2 लाख करछन्ती सेटा आमे करछु आमे सर्वे करिने आमे तेटा कलु जे सर्वे कले 6 लाख समर्स आमे 2 लाख समर्स काहे कलु ना दे फेल टू प्रोड्यूस द बिल्स एंड वाउचर्स तेणु आमे कोन कलु ना तुम बिल्स एंड वाउचर कलोनी तो किनी ना कि तुम प्लेस करी ना तुम पाखे तेणु आम 2 लाख समर्स कर एति खाली मत सब्सटेंस किसी मोर कहबार नहीं कि सेकेंड शॉट थर्ड शॉट कनसेप्ट उठुनी एग्जैक्टली से सब
bills have been produced man. Bills have been produced.
सेटा प्रोड्यूस कर दो मु देखि देबे मु सेटा एति जो लॉर्डशिप ऑलरेडी एक्सप्रेस मु से लेटर के देतो फ्लैग मार अभी विद अग्री
Right. छुट्टी पर छुट्टी पर
By the order letter dated 22/4/2024, the Salon Commission has directed to file an affidavit. I prefer another 2 weeks time to file the affidavit because the
And in the meantime, we have filed a written objection. That copy after, that copy we receive. हाँ कॉपी अटैच 3/2024 फाइल 3/2024 रिटर्न
next one written objection file करें जो बोलता copy टा attach करना I shall receive that.
हाँ सर सर कॉपी दे दे अटैच कर दो सर तुमटा दुटा कोड कागड़े दे दो कागड़े एकदम दे दो शॉर्ट टूटे लेते the copy of the written objection short today.
these are the loan account we have been dealt with all the these account but there is the name of said person
I shall submit that. I shall submit that document.
But if the affidavit is valid, we file a reply to that affidavit. Sir, we did
35
sir, date
24
In that case, Malik, very only judgment was pronounced.
May I start making this statement? Yes. And what I have come here to say, would you kindly permit me to say? Yes, but today I submitted just one page. Yes.
I have also extra copies of today's. I've sent to everyone, including the honorable courts. May I start? Just one page. I gave one copy to him. If you want more copies, I have. I have more copies. I'm sorry? No. Yes, enough, and this only the one page I wanted to read, but he had already read, so give a copy to him. And
What do I need to submit? I have submitted everything. Arguments is complete, everything is complete.
Order reserve.
thank you.
36.
The lots of population, item 37. So 36 टका है सर मुझे खाली परमिशन नहीं कहूँ सर आइटम 37 सर ठीक है मैं औषध खाई सर डायबिटीज खाली सर एटा मो रिटन नोट सर ये दे दे रेस्पोंडेंट दे दे रिटन नोट ऑफ सबमिशन मु आज रिटन नोट ऑफ सबमिशन का फाइल करछि सर ना और डेटा सब रिटन नोट तो रेस्पोंडेंट भी नाराज हो जाता है कॉपी भी दे दी आगे से नाराज सफल में वो कोई देख ले आगे
Matter 36. For the appellant bank, on last occasion 4 times notice has been issued to the respondent. They are not appearing.
and we have filed our written note of submission also. First initially notice was given on 27/11/2014. चार थर नोटिस जाइए से स्कीम रे जलनिधि स्कीम रे he availed some loan for digging a well. So his allegation before the district commission that he was not disposed with the entire amount of loan, but on the basis of field report, the bank didn't disburse the entire amount of loan amount because the well was not properly dug as per the instruction, and it took too much time to dug the well as well as. So there are some allegations by the secretary of that PAX society, secretary as well as president. They have alleged before the bank, because it's a cooperative bank, that it didn't disburse the loan, and it's totally discretion of the bank to disburse the loan to the farmer. हम रिटर्न नोट दे दी. Impute order is annexed, page 16, annex 4, impute judgment. Inspection report. एक्चुअली से कॉन्फ्लिक्ट थी पैक्स रो सोसाइटी सेक्रेटरी आउ प्रेसिडेंट एलिगेशन देले प्रॉपर्ली काम से करे नहीं, बट डिस्ट्रिक्ट एग्रीकल्चर रो गोटे स्टेटमेंट से देले 14 फीट वेट आउ 10 फीट डेप्थ रो खोला है सेटिक रो अटकी अछि सेटा फिजिबल रिपोर्ट रे बाहर तो माटी भी बैंक को
39
छुट्टी करो वैकेशन करो बस करो क्या टाइम 22 नहीं सर सेठी मारा गिराल डेरी हो
बलांगीर रो आसो डिस्ट्रिक्ट कोऑपरेटिव बैंक
बलांगीर
और रेकॉर्ड बहुत पुराना रेकॉर्ड है
10
June 20.
आगे
नहीं
And for the respondent, it's not the case. My last occasion, my hard by this court minor and directed the appellant to settle the matter and we will reduce some interest. And appellant counsel also agree. Subsequent case was posted to Lok Adalat. They are not coming now. ନା ଆସିନଥିଲେ ସେ ଆଜି ବି ଆସିନାହାନ୍ତି କିଛି ନାହିଁ ଠିକ୍ କରିକିନା ଗଡ଼ଉଛନ୍ତି ଏଗ୍ରି କରିଥିଲେ ସେଟଲ୍ କରିବା ପାଇଁ ଲୋକ ଅଦାଲତରେ ବି ଉଠିଥିଲା ମାର୍କ ତାପରେ ଆଉ ଆସିନାହାନ୍ତି ଏମିତି କରୁଛି ସରିଗଲାଣି ଆଜି 13 ତାରିଖ ଥିଲା ଗୋଟେ ଡେଟ୍ ଆଉ 20 ଯାଏଁ ଆଜ୍ଞା
So item number 2. Item number 27.
କୋଉଠି ଗାଁ ଯିବ ତମ କଟିକି ତମ କଟିକି ମୁଁ ଜଣା ପଡୁଛି ଆଉ ବାସ୍କରେ ଇଏ କଟିକି ପଡେ ହେଲା ଏ କଟିକି